Okay, hopefully everybody is in who wants to be in. We're going to go ahead and get started. First, welcome everybody to the legislative review. We have pretty much the same, most of the same panelists as we had last time. And I'll say it at the end too, but just a huge thanks to all my experts here who are giving us their time and talent on these bills. It's really helpful. There's so much experience on this panel. I think it just provides us such a load of information. And also if people have questions, you're lucky that probably one, if not three people have an answer for you. So again, my thanks to all of you for your time and talent that you share with us. So CIP, just a quick run through of who we are. We are a federally funded program under the AOCP in Nebraska. We help with multidisciplinary teams across Nebraska, known as Through the Eyes of the Child. Members, they're part of the community and they work to improve issues in the juvenile court system. Each team, they select their own projects and goals, just kind of based on the needs of their community and their court system. These are judge-led teams, and they are under the guidance of Judge Heidemann and Judge Rowland, along with our two chairs. Our team at CIP provide technical assistance. We do data and reporting. We help provide resources if we can to our local teams. And basically anything we can do to support our multidisciplinary teams in the communities. That's kind of what our primary focus is. We also have a priority of education, and we have events such as our annual regional conferences, lecture series, webinars, as this one is, as well as our Children's Summit, which is every 3 years, and this happens to be the third year. So just a little plug for us on, get that save the date on your calendar in September. So that's us in a nutshell. We're going to jump right in. There's not a lot of bills that passed this year, but the one that did is big, and we have some legislative resolutions too that are important. So I'm going to hand it off.
Our first presenter today is Sarah Helby, and she is a staff attorney and director of the Child Welfare Program with Nebraska Appleseed.
Okay, hi everyone. Thanks for that introduction. I'll just jump into it. I just want to thank Court Improvement for the opportunity to present. This is always a lot of fun. And then mention a couple of priorities that all passed into one package this session and then one interim study. And so the first, as you can see there, is LB 1173. As I said, this is a package of child welfare bills that was amended together as a Health and Human Services Committee priority bill. I know that several other presenters today are going to be talking about this, so I'll just try to give kind of a brief overview of all that's included in that. The original bill, LB 1173, was to create a work and strategic leadership group for child welfare reform. And this grew out of an evaluation of the Eastern Service Area privatization by the Special Investigative Committee on the Eastern Service Area. And so also out of that evaluation came a recommendation to end the Eastern Service Area pilot project. And as a result, the Health and Human Services Committee amended Senator Michaela Cavanaugh's bill from last session, which was originally LB 491, into the package. So among other things, Senator Cavanaugh's bill struck from our statute the authority of HHS to privatize case management services in the Eastern Service Area. Appleseed had some pending litigation alleging that statute was unconstitutional special legislation. So that bill had the effect of terminating our litigation, which is in process. So currently the statute is clear that all case management is to be provided by the department. And then LB 1173 also included an amended version of Senator Hunt's LB 932, which was the bill regarding Social Security benefits for children in foster care. This issue we mentioned in our earlier presentation, but it was brought to a lot of people's attention, just as a reminder, by a 2021 investigation by NPR and the Marshall Project, which found that a number of states, including Nebraska, receive foster youth Social Security benefits on the behalf of the child, and then use them to pay for the youth's care without notifying the youth, their family, or their attorney. In fiscal year 20, Nebraska received over $2.6 million in Social Security benefits on behalf of Nebraska's foster youth, again, without notification. Just as a reminder about Social Security, many youth in foster care qualify to receive these benefits either based on their parents qualifying for old age survivor or disability benefits, or in a lot of cases because the youth themselves qualify, and that would be in the case where a youth has a disability, including mental health. The payments are usually about $700 a month. So the original version of the bill sought to provide a number of protections for youth who receive Social Security benefits while in foster care, where the department becomes the benefit, like the representative payee, I think is the word, on behalf of the youth. The original bill included potentially screening all potentially eligible children and then saving a portion of benefits for them. However, the amended version that got put into LB 1173 scaled back significantly, but still requires HHS to provide notice to the child and the child's guardian ad litem when the department is the representative payee for the Social Security benefits of a child in foster care within 30 days of receiving the Social Security benefit on behalf of the child, as well as notice to the juvenile court at every review hearing, including the total amount of the funds that HHS has received, the total amount that has been conserved or unspent, and an accounting of all the records can also be provided upon request. So essentially, it ended up just providing some notice and information about the receipt of benefits, or the interception of benefits, I guess is a better way to say it. The package also included what was previously LB 541, which was introduced by Senator Walz regarding treatment family care, TFC. This is something that the Nebraska Children's Commission worked on quite a bit. As amended, it authorizes HHS to create additional levels of caregiving for youth in foster care, and to create an implementation plan for TFC services to expand the service array for high acuity youth. So this is like a type of wraparound services, and ensuring that we, increase this array and are able to compensate this foster homes that are able to provide this more intensive wraparound type of care for high needs kids. So specifically, the bill requires CFS to implement additional statewide tiers of reimbursement with standardized rates for foster parents and child placing agencies by October 1st, 2023, and then to implement a plan for that by, do I have these dates right? Get at my notes here, sorry. I think it's to implement the tiers by 2023, but the plan by October 2022. But I can double check and put in the chat if I have that wrong. That seems fast now that I look at that. So I can clarify, but there requires both the plan and the implementation. And then finally, the package included what was previously LB 854 that was introduced by Senator Jen Day. It requires CFS to immediately notify the Division of Public Health when they receive reports of abuse or neglect by a child care provider. And this was a result of a hearing that was, really difficult, or really difficult and sad stories were shared of parents who were not notified of abuse in child care facilities as a result of miscommunication or lack of communication across divisions of DHHS. So just clarified that notification needs to happen so that that those allegations can be provided to parents in those situations. So that's just a lot really quick, but as I said, I think some others are going to be talking about 1173. So I was hoping, since I'm going first, I could just give like a little overview and skeleton, and then others can, comment or give any updates on implementation. The last thing I wanted to mention is an interim study that will be a priority for Nebraska Appleseed, and that is LR 404. It was introduced by Senator McKinney. The purpose of the study is to examine racial and ethnic disproportionality in Nebraska's child welfare system, and specifically to look at the role of law enforcement at the front end of the system. That includes collecting data, including sources of referrals, looking at the role of law enforcement and the scope of authority of law enforcement within child welfare, and it also includes getting community input, importantly, on these issues. So we're really looking forward to working with Senator McKinney on this over the interim. With that, I will turn it over to the next presenter.
Sarah, and before we head to our next presenter, I did want to note if there are questions throughout the presentation, feel free to just drop them in the chat and we'll get to them throughout the presentation. So our next presenter is Bri McLarty. Bri is a deputy county attorney in Dodge County.
Hi, morning, everybody. So Sarah did a great job of an overview, which is great, so I don't have to do it. What I'll be talking about more is the practical application of what you'll actually see in the courtroom for those that are either practicing attorneys, defense, GAL, county attorneys, if you're a CASA representative, or if you're a foster parent or working with foster care agencies. So I'm going to kind of get to what you should be looking for in your family team meetings as well as your review hearings. So in talking about the SSI benefits, it's important to note that the rules and regulations for these notices aren't actually required to be promulgated till October of 2023, but they're required to start giving notice January of 2023. So I'm not quite sure what that's going to look like. It could be buried in the case plan. It could be a separate report that they attach to it. So just kind of start looking for that starting next January of, is this something that should be attached, or is this something that's kind of buried in, the update on the child information? Now they're required to give notice of the Social Security benefits 30 days from the receipt. So there's no notice that they've required notice for application. It's just that they actually apply, are approved, and receive payment for the juvenile. So for GALs and parents attorneys that are looking to kind of see like, well, is this happening? A great place to look would be the child information part of the court report that you get with the case plan court report. That'll list diagnoses. So that'll look if any of the kids have that developmental disability or one of the diagnoses that could qualify for for these Social Security benefits. So we definitely want to make sure that we're receiving notice, and that's a great place to start. So you can start asking questions of the caseworker and HHS saying, hey, I see they have this diagnosis. Have you applied? Now, they don't have to give you notice till they get the money, but that might be a great way to start to make sure you're actually receiving the notice once the money comes in. Another great place to start looking is also in the case plan section. They have, case plan goals for mom, case plan goals for dad. They also have them for the child at the very end. This will be really important if you're dealing with an older youth, maybe someone who is looking at independent living is their case plan permanency objective. So we'll have specific stuff for there about when they're going to start working with the PALS worker, when they're going to start meeting with their Bridge to Independence coordinator. Because if there's this money left over in this bank account, in theory, that goes to the youth. So that's something to flag in the case plan is, are they listing this funding and this bank account information as something that they're going to talk to the juvenile about as part of their independent living plan? So those are just two places that I would encourage you guys to start looking at once this notice requirement is going into effect next year. And then obviously the total accounting is not just what was received and what was spent, but how it was spent. That's not something that's required to be provided to the court, but it is required to be available upon request by the guardian ad litem, the parent. So if you're a parent's attorney, that's something to also consider as you're looking at reunification or even case closure. And then finally, the child themselves. Obviously, they'll probably do this through the guardian ad litem, but those are the three individuals that can request a specific accounting of how much money was spent and how it was spent in those situations. The provider rate, something to kind of think about with these wraparound foster homes that Sarah was talking about is start thinking when you have children that maybe keep having disrupted foster placements. So the foster parent keeps putting in a notice because just the behaviors are too much. In those family team meetings or in those conversations about change of placement, ask once these provider rates are implemented, is this the type of home that would be appropriate? This kid has burned through 3 foster placements. Is it because of their behaviors? And do they need this higher level of foster care? So that's something to always be asking at family team meetings or when you're looking at change of placement notices that are coming in and you're seeing that kind of that pattern. So something as those on the juvenile team to be aware of. The other thing I'm supposed to talk about is LR 386. It's an interim study that was introduced by Senator DeBoer. It's a pretty broad one. It just says to examine the juvenile code. Juvenile code's pretty long. I reached out to Senator DeBoer's office kind of asking what's the background for this. It was just brought to them by a lobbyist that works a lot in the juvenile justice system. And it's kind of a common thing that senators do. They don't quite know what they want to look at yet, but they want to cast a wide net so they have the foundation to do so. And there's two ways that this can happen. This could actually be picked up by, I think, can't remember which committee it got referred to, but can either be picked up by the committee where the actual committee chair is willing to organize or host or schedule public hearings about it, where everyone can come in and kind of provide information. Other times, senators, if it's not picked up by the committee, will kind of run with it on their own. So something for everyone to think about that are working here in this juvenile system, think about ways that you could maybe work outside of a typical public hearing kind of situation. Because this might be just Senator DeBoer having to do a lot of the legwork on her own. So think about how your organization can package information or package a panel or have a sit down with Senator DeBoer and interested senators about what you're seeing in the juvenile system, things that could possibly be changed in the juvenile code, things that you're running into kind of more frequently. So for example, I've already offered to Senator DeBoer's office if they'd love to come up and observe juvenile court. We have a great juvenile court in Dodge County where we have a mixture of probation and HHS cases that are interspersed throughout a Wednesday is our court day. So that'd be a great opportunity for her and her staff to kind of see how the law is actually being implemented in the courtroom. So think about if your organization has that capacity to provide some hands-on or observation experiences for the senator or even her staff. That might help them hone in on something they're seeing. For example, we're having some issues with paternity when we have a legal dad and a bio dad in some of the recent court cases that are kind of throwing a wrench in that. So that's something I'm definitely going to bring up to her as maybe we could modify the juvenile code and make it a little easier. So think about that, especially if there's not going to be a full-on public hearing, because I'm sure she still wants to look at what's going on in the juvenile code. And then finally, the last thing I'm going to talk about is ARPA funding. We got a boatload of money from the federal government for ARPA, and senators dispersed it across a bunch of different agencies. And so the ones that I kind of highlighted that we should all be aware of, one, money that's going to YRTC Kearney. There's also money that's going to increase provider rates. So for foster placements, as well as family support workers, visitation specialists, trying to pay those agencies more money so they can have a higher retention of foster placements as well as workers. So hopefully we'll see an improvement in some of the lack of providers that are working on the ground have seen with our cases where we're not getting visitation workers, we're not having those access to services that we typically used to have because of a worker shortage. So that's one of the ones. A couple others that I found really interesting were there's some grants to nonprofits for food security. So while not directly related to juvenile justice itself, knowing what's going on in your community about what nonprofits are receiving grants to improve food security are definitely things we want to look at when that's one of the core issues that we're seeing in our cases, that the parents may be struggling to provide the daily care. What resources are available in your community that they can rely on as supports versus kind of just constantly struggling with that issue, because that would delay case progress in a typical 3A case. So kind of just being aware of that. I think there's a lot of money going on. So those are kind of the main ones that I wanted to bring up on the funding. I forgot to mention one note on the earlier, Sarah talked about that there's a work group going on to kind of strategically look at child welfare. Specifically in statute, it requires that work group to consult with stakeholders. And I found it really interesting that the stakeholders listed included judges, people with lived experiences, and county attorneys. They didn't specifically list other attorneys involved in the court process, which seems a little strange to me. So I guess I would encourage that reach out to your county attorneys and share information that maybe they can pass on to the stakeholders, or this might be a great opportunity for through the eyes of the child teams to kind of look at what they want to make sure is shared with these with this work group that's being created. So that way it can be funneled through the county attorney, who's probably hopefully on your through the eyes of the child team. But I just thought it was strange that it was so limited in who they should consult with. But I think there's a way that we as a team, since we tend to work a lot together, can identify and make sure that information is getting passed up to that work group. But that's just the update I have. Yeah, like Sarah said, not a lot passed this year, but those are kind of the big highlights and some of the practical applications of what we might be seeing in the juvenile court going forward.
I'm going to mute again. Thanks so much for that. Was really great information. I will send it to our next presenter, Dennis Marks. Dennis is a deputy public defender in Sarpy County.
Thank you. And I want to thank everybody for attending this session. Practicing in juvenile court is it's a specialty practice. It's a specialty court, and I just appreciate everyone being here to, stay updated and current on the things that are going on with the laws in juvenile court. It makes the practice better and certainly assists our clients. There's really two topics that I was going to talk about. I'm going to start off by piggybacking on what Bree talked about with the LR 386 interim study. I'm not a real political person, so my understanding, and somebody can correct me, of the LR is it's an interim study between the last legislative session and the next legislative session. And as Bree talked about, a hearing can be called by the chair. Here it would be the chair of the Judiciary Committee, which is Senator Steve Lathrop. Senator Lathrop is term limited, so don't expect to have any hearings on that this summer. The resolution, this topic could involve issues that may eventually make its way to an LB, so a legislative bill in the next session, kind of like what Bree talked about. And I don't know, we'll just have to see. Now, Senator DeBoer brought this, I believe, this my understanding, was based on a request by the County Court Judges Association. That's the information I got. It wasn't the separate juvenile court judges, but the county court judges. I'm not quite sure the reasoning behind that or the basis, but it is kind of curious. And I also agree with Bree that we should be thinking about areas that perhaps we can improve on in the juvenile code. Competency is something now with the decision in Victor Al that I think there's a lot more questions than answers in that area, and maybe that's something that we can address legislatively. I'm a firm believer in having collateral consequences as part of a rights advisement. So, unlawful possession of a handgun, if a juvenile is adjudicated on a felony offense or a crime of domestic violence, and then I would also like to see juveniles informed when they're adjudicated on offenses which involve sexual harming, that although they don't have to register in Nebraska at this time, if they leave the state to live, to work, to go to school, even possibly to vacation, they may be required to register in that state and then re-register when we come back. The wording on that can be worked on, but those collateral consequences are something that we talk about with our clients in this office. I just don't know if that's done across the state, and that's something that should be done. But those are some areas I think that we could look at in the code, and of course there are others. It can always be streamlined to a certain degree. The second topic was the funding for the YRTC, where the legislature set about $15 million aside. The YRTC Kearney is not our grandfathers, Kearney. They are making a concerted effort to join the 21st century. Within the last couple of years, they've added some family engagement interventions and added more programming. This money's kind of been earmarked to build 2 new buildings, and it's going to specifically impact sleeping arrangements. Currently, the boys at Kearney sleep in it's kind of a fraternity type barracks bedroom setting. So if you can picture a room with a long row of bunk beds, that's kind of what their sleeping arrangement is right now. And that impacts safety. There have been some assaults that have occurred. And if you think about it, there can be rival gang members in the same bunk area. The bunkmate above you could be a rival gang member. So it impacts safety. And what this money is going to do is get a couple new buildings so these boys in Kearney can get individual bedrooms. They're going to be able to take ownership of those bedrooms. They'll be responsible for cleaning their own rooms. They'll be allowed to decorate their rooms, obviously appropriately. And what Nebraska is doing in this area is we're just joining what other states are doing. And it's also part of the best practices. The YRTC in Hastings and Lincoln, even Whitehall, those facilities all have individual rooms for youth. So Kearney needs that as well. I think it's important to remember that ultimately these boys are going to be discharged from Kearney and returning to the community so we want them to be successful while they're at Kearney, because if they're successful, then we can reduce the risk of reoffending. It's awfully difficult to be successful in school or engage in therapy or programming if you're having a hard time sleeping at night. To be successful in all of those things, you need to have that feeling of safety and security. I think by moving to individual rooms, we'll be able to achieve that for our youth at Kearney. And I'll take any questions either here or if you want to contact me directly on either of those 2 topics. Thanks.
Dennis, I'm glad you brought up the sex offender registry. That was one LR that I kind of remember in the back of my head, but there is legislative resolution 189, and they are going to examine whether juveniles adjudicated as sex offenders outside Nebraska could register as sex offenders if they move to Nebraska. So it might be something that people want to keep an eye on. It is Senator McAllister.
That's interesting because, there was originally an 8th Circuit case that said they didn't have to. And then the Nebraska Supreme Court just very quickly thereafter issued a decision that says, yes, you do. So I have had a couple clients who have come here out of state and have had to register here in Nebraska as juveniles. And it's very difficult. And when we're placing youth outside of the state, youth who have offenses involving sexual harming, we have to look at those states' registration requirements. I'm looking at Missouri right now on behalf of another client, because not every state requires, some states require lifetime registration. So when I talk to my clients, I tell them they literally have to do this for life, because there are states out there that require lifetime registration, including juveniles. There are some states that don't require it at all. And then there are states like Nebraska that require it for a certain number of years. But if you're in a state that requires lifetime registration and you don't register, you're going to be sitting in jail for months. So I just think, I hate to think that there's justice by geography, or I just want everybody to get the same level of representation and advice, you know, especially when it comes to this registration, because it can have such an impact if they're not aware going forward.
Thanks, Dennis. I appreciate all that information. Our next presenter is from the Douglas County Separate Juvenile Court, and we have today with us Judge Stephen.
Good afternoon, everybody. It's wonderful to be a part of this. I think trying to keep up on legislation related to juvenile law matters is so important. Legislatures have things brought to them, and they are not experts in that area and that field. And all of us need to assist in contributing as much as we possibly can so that things are consistent and apply to the reality of the situation that youth and families face in juvenile courts. So thank you for this. I am also assigned to speak about the interim study to examine the juvenile code, LR 386. And I think I can share some foundational information in regard to this. In 2018, the juvenile law section of the State Bar in Nebraska and Judge Patrick McDermott, a few people from the juvenile law section, and Judge McDermott did a presentation to the County Court Judges Association, asking them to consider and support an effort to update the juvenile code. And at that time, that was about just taking a look at it to get it consistent and timely with juvenile law practices as they existed at that time. I think the County Judges Association was very interested in that. For judges in Western Nebraska, there are a number of provisions of the juvenile code that are very complicated, related to detention and other matters, because they're so far away from youth. There's a number of statutes in the juvenile code that when you go to look things up just appear to be in the wrong place and at the wrong time. And there's been no comprehensive revision really since 2013. And there's been so much that has happened that I think the County Judges Association picked up this issue and approached the legislature about it. I absolutely believe, based on everything that I know, that the goal of this interim study is to take a look at how to organize, maybe rearrange some language in the code so that it accurately reflects the law and the rules as they stand at the time the final decisions are made. My impression is thus far that in terms of substantive types of changes, that the perception is those kinds of issues should be left in the hands of the legislature, and looking at the revision of the code, it should just reflect the law as it stands. Now, when you've got an interim study and you've got people working on it, that can change. But I think that's where it stands right now. And I think that kind of effort could be tremendously helpful to everybody. The other legislative bill that I was assigned to speak on was LB 1137. And I have lived through 3 huge revisions and changes to how Nebraska conducts child welfare work. And so based on that, I probably shouldn't, but actually want to preface my comments with a couple of things that I think I've learned through the years at working at this job as a prosecutor, as a private attorney, as a guardian ad litem, and now I only have 2.5 years on the bench. But you know, when states and state governments endeavor to step in to the life of a family because a child is in danger or can't be cared for, or a child is a danger to the community, I think governments were not prepared to parent. They weren't created for that purpose, which ends up with 2 big issues to address. One is the government, if it's going to intervene in the relationship between a child and parent has a tremendous responsibility to assure that that child gets the best possible care. And the second is that we are working with families and children who are struggling with really, really, really difficult things. So there will always be some mess to it. And if we are not willing to realistically look at that, then we will not be able to come up with realistic solutions. So I just think keeping those two things in mind is critical. But LB 1137, the legislature found that Nebraska needs to comprehensively transform its child welfare system and has determined that this will require an integrated practice and finance model. So they intend to look at both how child welfare is practiced and the financing behind it. And it needs to address all aspects involved in the system. And the intention is to involve the legislative, executive, and judicial branches of government. To accomplish this, the legislature is instructed that there will be a child welfare practice model group formed, and Sarah spoke of this a bit. That group will consist of, including but not limited to, the Director of Behavioral Health of DHHS, the Director of Child and Family Services Division of DHHS, the Director of Medicaid and Long-Term Care, the Commissioner of Education, and the State Court Administrator. And for all of those, they can also designate someone to appear on their behalf. They are encouraged to include other stakeholders or other professionals who work within the division. But they have a monumental task that they are working on. So if at any time you're approached by anyone who is part of this child welfare practice model work group, please talk with them and give them your input. Or if you know anybody who is assigned to this committee, please stay in contact with them about this. Transforming a child welfare system is a huge endeavor. And one more piece that I just want to throw out there for everybody who's going to be working on this and considering it is, over the last 5 or 6 years, I've been involved in exploring and investigating several different ways to transform how things are done in juvenile law in Nebraska. And we visited different model sites around the country to look at how other people do things. And in a couple of those, we discovered that actually Nebraska is doing much, much better than the place that was designated as the model site, based upon what we saw and the information we discovered. So as Nebraska looks to improve what we do, it's important to not lose what we do well. And those things need to be taken into consideration too. That child welfare practice model group is going to report to a strategic leadership group. And that group exists for the purpose of receiving updates from the work group. The members will share their work with the strategic leadership group. And then the strategic leadership group will report the work group's progress to the legislature judiciary committee. There are some deadlines involved in this work that can affect us. By December 15th of 2022, DHHS is to contract with an outside consultant who has expertise in the child welfare system transformation. The consultant shall assist the work group with the development of a written framework for practice and finance model development. So I think we've got a lot invested in who the consultant might be. And I was wondering if anybody has any updates on that, because I couldn't find any. Mary Pat, does CIP have any information?
CIP does not, but are lucky
I
that.
will speak to that.
Thank you,
Okay,
Director.
very good, because when I saw we were bringing an outside consultant in, which is always really important because we always need fresh perspective, the first thing I thought of was the outside consultants that I've experienced over the last 5 or 6 years who didn't know what we were doing in Nebraska and didn't know that there were things that we were doing well. And so my radar shot up. The second date to keep in mind is on or before December 1st of 2023, the work group is to submit their written practice and finance model framework to the HHS committee of the legislature. So we can anticipate exploration and those kinds of things happening and development of the model framework over 2023, and the report is due to the HHS Legislative Committee at the end of 2023. So there could be a lot going on with this over the next year. And I just want to encourage everybody to keep it on your radar. I will let you know that I did check in with everybody I could come up with, including the Supreme Court Administrator, to see if any steps had been taken to move forward on either LR 386 or LB 1173. And there have been no meetings scheduled, no judges or persons appointed to either of these committees at this point. So Dennis's point in regard to nothing might start soon, I'm putting that in my pocket. And I'm hoping that Stephanie Beasley may have more information. So if nobody has any questions, we will continue on with someone else.
Thanks so much, Judge Stevens. Our next presenters are with the Nebraska Department of Health and Human Services. Stephanie Beasley is the Director of the Division of Children and Family Services, and Ashley Peters is a Program Specialist. Welcome.
Good afternoon. Ashley actually is our manager over our policy work here, and so I'm joined here with her today. Very happy to be here, and I want to second many of the initial speakers that really appreciate and applaud the members who are on the call today and the participants. You know, this field is so very important. And I appreciate your desire to keep yourself informed of the legislation coming, educated, so that really you're doing the best work to support children and families and vulnerable persons across Nebraska. So thanks for having us here today. Thanks for being on. So I'll give a couple of the updates that Judge Stevens mentioned here in just a second on 1173. But I'll start with, I'm just going to kind of go down the list. On LB 541 that was rolled into 1173, and a current update on this is the Foster Care Rate Setting Committee had issued a report in June of 2020 recommending an additional tier. We spent really the rest of that year and all of 21 working with the Foster Care Rate Setting Committee and analyzing how many additional tiers are needed, and so we will be prepared to implement 2 additional tiers for foster care as of October 1st of 2022. Treatment foster care, which is being built and designed in concert between our division and Medicaid long-term care and others, the Rate Setting Committee, will actually be ready in 10 of 23. So they've really got some time to design the right treatment foster care system for Nebraska, and looking forward to 10 of 22. Our RFP actually for the additional 2 tiers will be released probably within the next few weeks, and so that will be coming. We will be ready to go for by a 10/1 date. The next thing, LB 854 actually is pretty simple and self-explanatory. It requires CFS, my division, to immediately notify our sister division of public health of any reports that we received of alleged out-of-home abuse or neglect by a child care provider or staff member. So that is pretty self-explanatory, and that process is being put into place. The next thing is the 932 LB, and that was introduced by Senator Hunt, requiring us to notify youth in foster care and their guardians, guardian ad litem, that the state is collecting Social Security. So I want to walk through a little bit of the process that we are putting into place. So we're required to implement this by January of 23. One of the key pieces is the notification. So once we've been notified as that we will be the child's representative payee for Social Security benefits, we will submit to both the beneficiary, the child's beneficiary, and guardian ad litem within 30 days that we have received notice that we have become the payee. For the cases that we have already received the child's payee notice, those notifications will be sent by January 31st of 2023. The next is that a report will be generated for every review hearing for the juvenile court to outline the total amount of Social Security benefit funds that both we have received on behalf of the child as of the review hearing and that are currently conserved or unspent as of the review hearing. And that report will actually come from the In-Focus Trust account. One of the things that's really important to note is that DHHS holds and saves the first $1,000 that is received by Social Security, and then additional dollars received are actually used for the care and support of the child, but that initial $1,000 is conserved. All records around our receipt, use, and conservation of Social Security benefits will be reported upon request to the beneficiary, the guardian ad litem or attorney, or the child's parent. We intend to develop an email inbox that requests will be submitted to and then processed by DHHS, and that will make it just an ease of use and an ease of access to submit that question. We'll make sure that the information about the email inbox and the email address is widely dispersed. We'll complete all of those requests within 30 days, and again, it's the guardianship trust account in focus report that will be submitted at request. And then once we are notified of the termination of our role as the child's beneficiary representative payee, we'll submit a report regarding, again, the receipt, use, and amount of any dollars that were unspent. We'll submit that report to the child's parent, the child's beneficiary, and the child's guardian ad litem or attorney. Information regarding how the child's parent or child's beneficiary must apply to be the payee for Social Security benefits will be sent to the child's parent, the child's beneficiary, and the child's guardian ad litem or attorney. Social Security benefits do not automatically return to the original payee. One of the things that we're working on is how to automate the process to ensure that we can exceed 30-day timelines or minimize 30-day timelines and really be more efficient in that. But that's a process that we're working through right now. I'll have information as we go along. And then the last thing that I'll talk about really is the broader process of LB 1173 and the focus really on child welfare practice in the state of Nebraska. One of the things that we've been doing the last year and a half has been convening, and who we've had at the table have been tribal partners, county attorney, judge, Children's Commission member, behavioral health, Nebraska Children's Court Improvement Project, Child Advocacy Centers, Inspector General, FCRO, but most important, persons with lived experience. So we've been convening over the course of the last 15 months to really talk about our model of practice across all of our organizations. Oh, and the Department of Education was also at the table. And I think it's going to be a fantastic springboard for the work of this commission. We just met again last week, and we meet again on June 13th, I think is the next date, really to talk about what we're trying to accomplish and outcomes. I see a lot of the groundwork as being laid for this work, really understanding multiple strategies that are being engaged across Nebraska to improve outcomes for kids and families, to do things, improve families staying intact, being served in the community, and the well-being for children. So I think we've done a lot of exciting work that is very groundbreaking and ground setting for the work of the committee as it comes. We also have been putting our scope of work together. We certainly, that RFP will be coming from Children and Family Services with the Department of Health and Human Services. So the scope of work for that consultant is being drafted as we speak. And so that RFP will come out for consultants to bid. We certainly will announce that widely. Would love to have a lot of eyes and opportunities for consultants to review and determine if they want to be involved in this very important work moving forward. So very excited to get started into this next chapter of understanding the strategies that each of us are bringing to the table around the well-being for kids and families and the work that still needs to be done. So with that, I'm going to give this back to our partners with the Court Improvement Project.
Thank you. And Director Beasley, we did get one question in the chat. Can you state again, when will state treatment foster care be available in Nebraska?
October of 2023.
Okay, thank you. We have a final presenter, is Elizabeth Eynon-Korda. She is a managing attorney with Education Rights Counsel.
Hey everyone, thank you so much. And I do want to echo what everyone has said about how important it is that we come through as a team. For those of you that are not familiar with Education Rights Counsel and our work, one of the things, we actually provide direct representation for families as well as we do training and research. And one of the unique things that we have been doing is working in Douglas County directly with the juvenile courts, accepting limited representation education counsel. And we're doing that precisely so that we are trying to ensure, as the judge said, the best possible care. And as I think DHHS said, for our most vulnerable children, because what we are finding is that many of our children in the juvenile system have special needs, have educational needs where they need additional support that they can obtain within the PK-12 structure so that they can meet the requirements of staying in school, actually getting their education, attending, not being truant. All of these challenges are a part and parcel of what we face along with everything else that everyone is dealing with in juvenile court. So my job today is to just simply talk about 3 interim resolutions that are coming that I think are important for all of us that practice. They're slightly outside, the day-to-day, what's it going to look like in court immediately, but they are places where all of us may have a voice because of what we are seeing in the challenges and the gaps, which Education Rights Counsel tries to fulfill in the education area. So the first LR is an interim study to examine the education experiences and outcomes of youth in foster care. And I know I'm preaching to the choir here. I know that everyone knows that sometimes our foster parents have such a struggle, especially with the highest needs students, to make sure that they too are getting the education that they're supposed to get. And when we have the children that are in what we call an education world level 3, those are the very high need schools that, prime home or someplace for a child that may be nonverbal or need severe behavior assistance. And this is an opportunity to talk about what the children in foster care are experiencing in terms of the challenges of getting their education, along with studies in terms of racial, economic, and geographic disparities, potential programs that can address the challenges for educational success specifically for youth in foster care, and the landscape of opportunities, and how to support foster care with their educational goals. So clearly this is an LR that Education Rights Counsel is very interested in, and many of you who are worried about how to make sure that when you're seeing those educational gaps that are getting exacerbated because of foster care, you may want to have a say. I do want to say that I too looked, and right now it's so early, I think people are just thanking themselves that they're getting a little bit of a break. There's no action on any of these LRs. We are directly reaching out to the senators to offer our assistance and input to make sure if they, depending on whether they're going to have a hearing, if we can facilitate that, whether we can bring testifiers or serve as a testifier if there will be one, or simply bring our lived experience. The second LR I wanted to draw your attention to, because I am cognizant of being respectful of everyone's time, is LR 414. This is also being introduced by Senator McDonnell, and it's an interim study to examine the programming, opportunities, and interventions of students attending alternative schools, classes, or educational programs. A lot of the students that you are working with, a lot of the juveniles, are going to be in these alternative schools. Unfortunately, it is our lived experience that these alternative schools do not have the knowledge, support, or resources, especially to meet the needs of children with regard to children who have an individual education plan because they're eligible for special education services, whether that's an emotional disturbance or an academic delay. We are working hard on ensuring that everyone understands the rights of those children, because what many people don't understand is just because you are placed into an alternative learning facility, it does not mean that you've lost your educational rights. And the way our statutes are set up in Nebraska, schools continue to be obligated to provide the same services under those individual education plans, regardless of the placement of the student when they move them from one setting to a different programmatic setting. So again, this is an important area, and if you have lived experience, it will be really important to talk with the senator about it. The final legislative resolution I wanted to talk about is the interim study to examine the education process and procedures for serving students with special needs. I have reached out to Senator Hansen. I'm not quite sure, but I think this is a carryover from legislation that Senator Luann Linehan introduced last session to ensure that if you are a child with special needs, you experience the same rights as other children with regard to choice of schools. We have in statute that we have something called option enrollment. So this often helps students in the juvenile setting do a reset if they can start in a new area. But we have what we have testified as direct discrimination on its face against students with disabilities, because all schools are allowed to refuse students with special needs from optioning and do so regularly. So this is I believe, a true equitable issue with regard to discrimination, as well as important to understand what the opportunities are for youth in terms of trying to make sure that they can meet their educational needs. It's 1 o'clock. And with that, if anybody has any questions, I'd be happy to talk with you later. I think my contact information, if you go to Education Rights Council, you can reach out to us with any questions you have. We provide consults to anybody and everybody. Thank you.
Thank you, Elizabeth. Okay, I know it's 1:01 now, and I'm going to keep you another minute over. I just wanted to put it just really quick. There is another LR out there. It's 423, and they are studying the current arrangement of court appointment of attorneys. And that doesn't include court appointments in juvenile court. I know a lot of people on the call work in juvenile court. That is Senator John Kavanaugh. So you may want to reach out to his office and see where that's going to be. That is all of our time, and I'm shooting it back over to my coworker.
This has been approved for 1 hour of CLEs, and the number is on the screen right now. And then just a save the date for the Children's Summit. It's going to be September 13th and September 14th in Kearney. So thank you all again, especially to our presenters. Again, we cannot reiterate that this would be a very boring webinar without all of your varying perspectives. So we really appreciate you taking your lunch to educate us about some of the bills that are going to be impacting our community. So thank you all.